Welcome, everyone. I'm really pleased you were able to join us today. Before we begin, I'd like to go over some housekeeping matters. First of all, pursuant to Utah Supreme Court rule, you have to stay on the entire 60 minutes in order to get credit. If for any reason you bump off and you sign in using a different ID, for example, if your original sign-in was using an email and then you subsequently sign in using a phone number, please email me at lori.nelson10. No, wrong. I said the wrong one. lori.nelson@law.utah.edu so I can make sure you get credit. You don't need to email me for any other reason, just if you bump off and then sign back on using a different ID. Also, for purposes of this presentation, please don't use the chat. If you have a question, put it in the Q&A and we will get those questions answered as we move through the webinar. Now, I'm honored and pleased to be able to turn the time over to Landon Troester at Clyde, who will move us through the Corporate Transparency Act. Thank you, Landon.
Thanks, Lori, and thanks everyone for joining. My name's Landon. I work at Clyde, Snow & Sessions. We're a general practice law firm here in Salt Lake. My practice focuses on corporate matters, transactions, mergers and acquisitions, and those sorts of issues. And I just moved offices, so apologies for the wall art on the ground. But today we're going to talk about the Corporate Transparency Act, which I think a lot of you have heard about. I know I have a lot of clients who are asking questions, and there's a lot of emails flying around about for CLEs and other services that want to fix this for you. So we're going to talk about it today, and we'll kind of take it through both what it requires and how you actually do the thing. So I'll get a PowerPoint slide rolling here. And so essentially what we're going to take through is a few-step process, which is talk about what this law requires, how lawyers kind of interact with this law. It's ultimately a reporting regime, and exactly what value lawyers can bring to that kind of depends on the client. Then we'll talk kind of on the administrative side as to how a law firm can process these sorts of things, and how to do so in a way that's efficient and helpful for your clients, and hopefully we'll give everybody a foundation to work with. So to get started on what the Corporate Transparency Act requires, I wanted to start with a brief history of what this law is doing and who is enforcing it. The Corporate Transparency Act was passed a few years ago as part of an omnibus bill. It essentially pushes the Financial Crimes Enforcement Network, or FinCEN, to develop a reporting system about business ownership, who the major owners and control persons are for a variety of businesses in the United States. After a few rounds of rulemaking last year, the reporting system just went live last month. And I think you're going to see increasing questions as we move towards the end of the year, where there's a major reporting obligation cliff that comes into play. The goal of this law is to essentially require nearly every business entity that's formed under the laws of a state or the United States, as well as foreign companies which are registered to do business in the state, to confirm that they are exempt, or if not, collect and report what's called BOI, or beneficial owner information. This information is then reported to FinCEN. FinCEN effectively acts as a bit of a data broker in this role. And the goal is to try and ban anonymous shell companies, or at least try to. That's the summary from one of the third-party kind of comments on this law as its purpose, which is part of why it restricts and limits the use of bearer share corporations, or bearer shares in corporations and LLCs. So what exactly does FinCEN do? FinCEN enforces a variety of laws regarding money laundering and terrorism. If you work in the financial industry, the Bank Secrecy Act is one of your main friends, and FinCEN is the entity that deals with that. FinCEN gathers this information and makes it available to other regulators and law enforcement agencies. The Treasury Department uses this information, as do a variety of state and federal law enforcement entities. Now moving to the CTA. The Corporate Transparency Act has this two stages. First, each reporting company must submit to FinCEN a report that contains a variety of information. And that report must identify each beneficial owner of the reporting company. So to distill that, you have kind of three questions. First, is the company a reporting company that has to collect this information? And the initial scope is very, very broad, but there are 23 different exemptions and more may come out through regulation. And we're going to walk through the big ones of those today. Second, who is a beneficial owner? There are some very obvious people. There's a 25% ownership threshold, which we'll talk about. And then there are some shades of gray about what control over a business is adequate to be reportable. And then the logistics. Who do you report to? What do you report to them? And how do you do it? One thing to keep in mind is that if you're an attorney that forms businesses for clients, depending on your role in that, you yourself may have to report your activities in connection with forming these businesses. Fortunately, that is relatively easy. We're going to talk about why, but it's something to keep an eye on if you incorporate businesses for people, especially if you name yourself as incorporator. So we'll talk about that a little bit later. Let's start with step one. Is it a reporting company? The language of the statute's on the right hand of the screen. I'm not going to read it aloud. Essentially, if you create a business or create an entity by filing a document with the Secretary of State or the state's equivalent of that office, or if you're a foreign entity that registers to do business through a filing of a document with the Secretary of State, you're likely included in this scope. It's clearly targeted at corporations and LLCs, but other business entities that are formed by filing with the Secretary of State to register your existence and receive sort of liability protections, you're at risk here of needing to do the work and comply with the Corporate Transparency Act. There are 23 exemptions. They run for a wide variety. We're not going to talk about all of them today. A number of them are very simple and we only have an hour and it's not that interesting of work. So we're going to talk big picture about what types of things you should watch for when you're working through these issues. And then you would want to refer to the enforcement regulations to determine if you meet the boxes specifically. Let's go big picture. The main exemption categories are here, or at least as I've summarized them, and I could be wrong, but I think these are fair summaries of what we're dealing with. The first two are public companies, which are registered with the SEC and have to provide reporting information, as well as entities that are subject to similar or related disclosure systems. I'll show you a list for your own curiosity, but in essence, these are entities that have to report a lot of owner information to the government already, and FinCEN did not want to, or Congress did not want to duplicate this work by requiring you to then report the same information again to FinCEN through the Corporate Transparency Act. Then there's governmental entities. Of course, there's an exemption for governmental entities created by law, which are doing certain types of governmental qualifying activity. And then the blue and the gray are the ones that I think are most interesting for your typical client, especially if they're not a public company, which is the large operating company exemption, inactive entities, and wholly owned subsidiaries of entities which are themselves Corporate Transparency Act exempt. So we're going to talk about each of these. But in summary, we have entities that are already disclosed, entities that are trusted and are protected by Congress. And then we have what I would call low-risk entities. Remember that this is a money laundering law designed to make sure that they know that the government and law enforcement agencies know who owns businesses. Large companies with a lot of employees and have serious revenue are less likely, I suppose, to be engaged in money laundering, though white-collar attorneys may quibble with that. And inactive entities as well, I think is largely to provide a reality check that there are a lot of dormant entities out there that have no operations or assets, and so they don't need to be reported. I'm going to talk through kind of those first three boxes briefly. I don't think they're particular focus for general attorneys, but of course, if you do public company work or if you work in regulated spaces, you're going to want to spend some time here. Public companies, here's the language of the statute. Essentially, if your business has classes of securities that are registered under particular subparts of the Securities Exchange Act or are required to report, even though maybe they haven't technically registered through Section 15D, you're implicated here. And this isn't too difficult of an issue. I'm not going to spend a lot of time on it. This is a summary of our other entities that are subject to disclosure regimes. Banks, credit unions, money transmitters, insurance companies who meet the elements typically in summary that you register and are kind of reported to state or federal regulators already. certain nonprofits for the same reason, public accounting firms, but those are public accounting firms. It's not just accountants. There's a specific trigger that you need to meet in order to be exempt there. Then again, we're going briefly. We have our sort of government affiliated entities. There is a second element to this, which could trip people up if you're not careful, which is under the statute, you need to be exercising governmental authority on behalf of the United States or some sort of political subdivision. And so it isn't just that you've been established under the laws of the United States necessarily. You also need to be exercising governmental authority. What exactly that means, I don't work with government entities, so I'm the wrong person to ask, but be aware that it's out there if you have governmental affiliated clients. Let's spend some more time on our last few. Large operating companies, I think, is the most likely exemption to consider when you're dealing with clients who are not specialized or regulated. It's an entity that employs more than 20 employees on a full-time basis within the United States, has at least $5 million in gross receipts or sales based on federal tax return filings, and has an operating presence in the United States. The last one is pretty simple. We're going to talk about the first two. And for a basic client or a basic business, this is relatively self-explanatory. Full-time employees, at least 20 of them, adequate federal tax return reporting in gross receipts. The complications here are going to be if you have a client with multiple business entities that are affiliated, work together. I think you're going to have a greater challenge and you're going to need to parse the statute and regulations a little more carefully. With these two sections, both rely on tax standards. I've quoted one of them. It's a little wordy, and I've summarized the other. But both of these regulations borrow from tax standards, summarizing generally the 30-plus hour a week from the Internal Revenue Code, but you'd need to refer a little more carefully if you're on the precipice or kind of in a gray area. And the 5 million requires that it be reported on a particular tax return form. So you're, again, going to want to be familiar with the Internal Revenue Code regulations, or at least review them if you're on the precipice or have an edge case. It's going to depend. The ambiguity that I've been kind of wondering about in this is, what if you have a group of entities that are affiliated with each other? Can you pool employees of an affiliated group of companies? If you have a structure where there are multiple LLCs, one LLC is the employer, technically, for structural reasons, but the employees perform services for others. That's something to chase down. And it's not something that I have a clear answer today. You're going to, the answer to it is hiding in the Internal Revenue Code and Treasury regulations about employee sharing. Some third-party commentators that I've looked at note that the Internal Revenue Code adopts a sort of common law test for certain situations. It's potentially an option, though it needs to get chased down more fully. Relatedly, what about the $5 million? If you have a network of companies that as a group are doing more than $5 million in gross receipts in a year, what does that mean for the Corporate Transparency Act? Again, it's punting to the Internal Revenue Services regulations and Internal Revenue Code. There's a consolidated group return rule inside the Corporate Transparency Act that allows you to use a consolidated tax returns number for each of the entities that file that consolidated return. The exact scope of that is going to require you to look at the Internal Revenue Code and regulations to make sure that you're hitting all the buttons, or the check boxes, I suppose, to make sure that you qualify there. It's something to consider when you have multiple companies that are working together, but it's going to require a closer look. I think for typical companies, single owners or single entities, this is a simpler exemption. The risk, though, or the ambiguities are going to be when you have multiple companies that are trying to share these resources and what exactly that means for the Corporate Transparency Act. Then let's move on to inactive entities. This one's relatively difficult to satisfy. You need to be in existence for over 1 year. I do have an asterisk there that we're going to talk about on the next slide. Can't be engaged in any active business, not be owned directly or indirectly by a foreign person. And you can't be doing essentially any sort of cash transactions. If you have a change in ownership or you've been sending or receiving funds greater than $1,000, you do not meet this element here. And you quite simply can't hold assets. I don't know, but I suspect that this is likely to create some carve outs for people who've kind of forgotten that they have an LLC, that it's been wound down but hasn't been dissolved, or it's been largely abandoned. It provides kind of a protection for those people who have accidentally not reported to FinCEN about their operations. The caveat on the 1-year rule is that FinCEN regulations specify the entity needs to be in existence before January 1st, 2020. So if you're relying on this, you're going to need to keep that in mind, and perhaps there's going to be clarifying regulation or rulemaking about that, and we'll see what comes of that. The final one, and the one that is again going to relate specifically to when you have a multi-entity structure for your client's business, is subsidiaries. It's useful, but there are limitations to this. And the thing to keep in mind, based on the language at the bottom of this screen, is that it is a corporation, limited liability, or et cetera, of which the ownership interests are owned or controlled directly or indirectly by one or more exempt entity. That creates kind of this directional piece that a subsidiary may be able to rely on the exemption of its parent, but not necessarily the other way around. And so that's going to have some implications as you're dealing with an affiliated group of companies on who owns what and which one is relying on which exemption. Another piece to keep in mind is that FinCEN specifically rejected a request that this subsidiary rule go both directions. There are a number of commentators who requested FinCEN to allow holding companies, holding companies that only own exempt companies, to itself be exempt. And the Corporate Transparency Act does not allow that by its own statutory language, and FinCEN rejected interpreting it in that way. And so that is not something that FinCEN seems very interested in taking on at this time. Another question is, what about partially owned subsidiaries? If a Corporate Transparency Act exempt parent has a partially owned subsidiary, but it doesn't own all 100% of its equity interests, it's not exempt by the language of the statute or regulations necessarily, but there are some limitations and implications for BOI reporting. We're going to talk about that soon, about who you have to report and what information you need to provide. But it is something to keep in mind, is that there are some simplifications that FinCEN has allowed if you have a subsidiary company that is only partially owned by an exempt holding company or owner. So that takes us through kind of stage one. Is it a reporting company? And I'd summarize the hot topics that I'm seeing and that I think are most concerning to me, though I think different attorneys and different practice groups will probably have some other questions, which is, for large operating companies, you're going to need to look to the IRS regulations on when you have companies that share employees or file consolidated returns. And relatedly, for subsidiaries, the statute requires that the ownerships be controlled directly or indirectly by some sort of exempt owner. Indirect isn't particularly clear here. So again, you're going to need to keep an eye on your ownership table and what this indirect ownership may look like. My takeaways are that each entity needs to qualify, and that you need to be careful when you're using a consolidated group or a networked kind of affiliated group of companies. Don't want to belabor this point too much, but it's the action that I've been spending the most time on in the most recent weeks. And subsidiary exemptions are going to help, but it is direction specific. That's a lot of information. We've talked a lot about different exemptions. Now let's move on to beneficial owners. And this one is similar in that the big picture is relatively straightforward. You may have some challenges or gray areas at the margins, particularly when you have complicated ownership structures. That's a recurring theme of this CLE, is that complicated ownership structures, complicated equity arrangements are going to raise some complications. The easy part for who a beneficial owner is it is an individual who, directly or indirectly, either exercises substantial control or owns or controls at least 25% in interests of the reporting company. Those on their own are simple enough. There are exclusions: minor children, individuals who are acting as agents, a couple others as well. But the big picture is 25% ownership or substantial control. The other easy points that we can kind of get out of the way pretty quickly. What if you have an entity that is the owner of the reporting company, whether in whole or in part? What if your reporting company is owned in part by an LLC? The regulations direct you to look through that and determine who the controllers of that intermediary entity are. And they've provided some guidance that we're going to talk about. And I even have a chart that'll hopefully help illustrate this issue for you. That if you have an LLC owned by another LLC owned by two individuals, you need to look through to those two individuals and see what the ownership interests are. And to come back to my point earlier, what if the company at issue is partially owned by something that's Corporate Transparency Act exempt? You don't need to report the beneficial owner information of owners who only own portions of this business through an exempt entity. This is designed, I think, to simplify administrative rule keeping. If you have let's take a public company, for example, that has a partially owned subsidiary, you don't have to look at the entire public company's cap structure and stock ownership section to get the beneficial owner information. You can just tell FinCEN about this exempt entity and move forward from there. There are some fuzzier questions. What exactly is substantial control? It smells like something ripe for litigation and multi-factor balancing tests. Similarly, what about owning or controlling 25% of ownership interests? And what exactly does control mean? I think that's going to be difficult, especially if you have ownership through trusts or other sort of entity intermediaries. To talk about substantial control, the 4 criteria are set out in the statute. A senior officer, which I would kind of summarize as a C-suite type officer, having appointment or removal authority over your senior officers or a majority of the board of directors. Now, those are separate, either having removal authority over a senior officer or having appointment or removal authority over a majority of the board. Important decision makers, which is a fuzzy type of situation. And then any other kind of fact, this is FinCEN's carve out of having substantial control over the reporting company based on the facts and circumstances that are presented.
Landon, could I just interrupt you for a second?
Fire away.
If the 25% is the beneficial ownership threshold for reporting purposes, what about a corporate entity that has 5 owners, each having an equal 20% ownership interest? Does that corporation need to report under the Act to FinCEN?
It's a good question. And under the 25% standard, and I'm sorry, I had to back up a little bit. Under the 25% standard, not necessarily, but remember that this is an or element. So an individual who exercises substantial control over the company or owns or controls at least 25% interests. So the 25% answer is fortunately easy, right? 20% is not 25, but some of those owners, at least if they are operating the business, are going to meet the substantial control test in some other way.
Thanks. Okay. Are trusts included in the Act?
So trusts will depend slightly. The statute specifies that these are entities created by filing documents with the Secretary of State. For people who are curious about the boundaries of that, FinCEN's rulemaking notes that they believe that certain trusts will have to be a reporting company because they do have to file certain documents with the Secretary of State's office. FinCEN has, though, indicated that they acknowledge that most trusts do not require some sort of document with the Secretary of State or similar office. And so that's where FinCEN appears to be taking it, is that when you have a registration form or certain types of business trusts, perhaps, but when you have a trust that is not created through filing documents with the Secretary of State, likely not.
Thanks.
You bet. So this form, and fortunately it's a little small, so I apologize. This is directly from FinCEN's Small Business Compliance Guide, which I recommend people look through as you have questions. This is kind of their summary of substantial control, which relates to Lori's question about what if you have a corporation with 5 owners? The next question is, well, what about the control they have? Many of those corporation owners are likely to meet one or more of these. A senior officer, which they specify as someone who has the authority of or equivalent to the president, CFO, CEO, COO. One interesting point that I noticed is that they include general counsel in this list. It is not particularly well explained why, but it's something to keep in mind for any in-house attorneys who are working for companies. They do not include secretary, the corporate secretary. For people who organize businesses, you're familiar that a corporate secretary is very common. FinCEN's determined that typically that is an honorary role or a role that's relatively clerical, so they did not include secretary in this definition. The important thing to keep in mind on the senior officer standard, this top left quadrant, is that it doesn't matter what your title is. Look to the economic realities of the situation. If someone has the power that is equivalent to a CEO, even if they're called the vice president of something, FinCEN's view is that if they have the power of a CEO, they are going to be reportable as a senior officer if they have that type of authority. The next quadrant is appointment or removal authority. And these are individuals with the ability to appoint or remove any senior officer or majority of the board of directors. Note, it does specify majority of the board. Here, I think your likely interest and your difficult spots are for those of you who have shareholders agreements, preferred stockholders, or other types of specialty rights for, say, an important investor or a founder who has founder share protection about appointing members to the board. This will require some parsing because on your 25% standard, no one may have power to appoint or remove, say, the majority of the boards unilaterally. But if someone has sort of founder shares or other types of preferred rights that give them this power, well, you're now solidly in the substantial control category, and it's something to think about. The fuzzier exemption and the longer one, or excuse me, not exemption, the fuzzier standard for substantial control, and as you can see, it's much longer, is an important decision maker. This is any individual who directs, determines, or has, quote, substantial influence over important decisions made by the company, including its business, finances, and structure. And when I first read this, I had a concern, which is important decision maker, I feel like moves far beyond your C-suite, moves well beyond your kind of president, CEO, CFO. And my concern is, what about employees? What about vice presidents of sales, directors for a particular region, or other people who have an important role to play in the company? But they might not own significant portions of stock. They might not be on the board. They might not own any of the company at all, depending on the business's structure. The important thing to remember as you're working through substantial control is that with the exception of senior officers, ignore your C-suite here, substantial control does not include employees who are acting solely as an employee, and so their control is derived only from their employment status. So all things being equal, if you have a vice president of sales for the Intermountain region who has control over whether or not to expand into a new state or not, you have a potential out here if the only reason they have that authority is because they're just an employee. It's a different question if they own 30% of the company as well. This is not going to be applicable to them. But it is an important out for your standard employees who fall below the C-suite level or fall below the senior officer level. That's substantial control. And again, to kind of reiterate this point, it is an or question. 25% of the equity interest of the company or substantial control. Substantial control is the one that I think will more likely be fact-specific and case-dependent because of this question about having appointment and removal authority or having important or a substantial influence over important decisions. There can be some quirks to the 25% ownership interest discussion. The thing to keep in mind is that this could get complicated where, again, you have preferred shares, convertible securities, and other types of atypical, not just common stock relationships. These are some summaries from the FinCEN regulations. If you do have complicated ownership structures or ownership structures with preferred interests, convertible interests, I encourage you to refer to the regs. You need to assume, and this is the language from the reg, and it does not provide a lot of other guidance, assume that options or similar interests of the individual are exercised, and then look at their relative control and ownership of the value of the company both. So if we look at this corporation language, you'll see it references to having voting power compared to the total kind of voting power of the company, and also value of the shares as a percentage of total value. So potentially you could have some differing outcomes here depending on how voting is structured within your corporation. This is a lot of info about substantial control, 25%. Let's just use a graphic. This is pulled again from the Financial Crimes Enforcement Network's guidance and small business guide. And we have an ownership structure here that I think is going to be typical of your complicated questions. You have the reporting company at the top, basic corporation issuing stock, We're just dealing with common stock here. Its direct owners are company Y and Z. And its indirect owners are the six, I suppose it's 5 people at the bottom. You'll see individual A is on there twice. And I think if I'm really good, there we go. You have individual A on there twice, both here owning portion of company Y and here as a portion of company Z. And so the question is, who are your beneficial owners under both the 25% test and substantial control elements? I'm not going to belabor the point too hard. Let's just provide the answers on the left, and you'll see that we have A, B, C, and F. A is CFO. They're a senior officer. They also own 15% of the reporting company through company Y. They own 30% of Y. Y owns half of reporting company, 15%. Similarly, they own 25% of Z. Z owns half of the reporting company. That nets to you to a 27.5%. B is simpler. 70% cut in half, more than 25%, they're reported here. C does not own enough stock, but is CEO and president. They're a senior officer. And then F is going to be the challenge, I think. F directs important decisions through board representation, whatever that means for you. This is an important decision maker person. If you have people like this, you're going to need to be cautious and deliberate about reporting them or not. And, I think some attorneys will take a more compliance and risk avoidance effort. Others will want to try and simplify their reporting and not bug this individual F, who clearly has some sort of special role in this company. Hopefully they won't come up too often. Typically, people who have important decisions through board representation are also owners of the company and have control over the board members. But this is your ambiguous circle individual F, someone that you should keep in mind as you're working through. So to kind of do our takeaway on beneficial owners, you should watch for upstream and downstream ownership and control, as well as parent and subsidiary type relationships. Remember that in that organization structure that FinCEN created for their guidance, that was one company owned by 2 companies owned by 5 people. And that can happen, and it takes a little bit of work to frame it out and see what's going on. Also remember that employees are not necessarily beneficial owners. However, if they have control over the business because of some reason other than just being an employee, you need to watch for that and potentially include them as a beneficial owner. And it's kind of our rundown of the 2 big pieces of this. To recap very briefly, a reporting company requires that you be a business formed by filing documents with the Secretary of State with a lot of exemptions. I think your large operating company is one to keep in mind, as well as subsidiaries. And then for beneficial owners, you have some probably very clear people, 25% plus owners, for example. Then you have some gray. If we look back to kind of Lori's question about 5 owners, 20% each, none of them hit that 25% threshold. But in a typical business, unless your structure is relatively weird, some or all of those people will be CEO, president, CFO. Some of them may have majority board control through a shareholders agreement, for example. The founder may have the right to appoint 2 of the 3 members of the board of directors, something to watch for. And that hopefully kind of takes you through the big picture questions. Now let's talk about how you do this thing. You have to report, if a reporting company is not exempt, they have to report beneficial owner information as well as company applicants. Now, this is only for entities formed this year. So for all the entities that we as attorneys have formed over the last, 5+ years, this is not a major concern. For entities formed this year and going forward, though, the individual who directly files the document that creates the company, as well as the individual who is primarily responsible for causing that document to be filed, are company applicants, and their information has to be reported as well. And this comes up because I think for many attorneys, you may choose to act as the incorporator for a business to file the documents with the Secretary of State. Typically, you're drafting them as well. And you're filing and even identifying and signing as an incorporator. And then you're, once shares are issued, you're resigning and having your client proceed and manage the business as they will. Even if you aren't the one signing it, you're likely, at least, depending on how your business is structured, you or your legal assistant are likely to be the people filing the thing. So you want to keep an eye out for company applicants and, keep that in mind. Fortunately, there's a way to simplify your part of that reporting process, and we'll talk about that. This is the language specific from, again, the FinCEN compliance guide, and it talks about this direct filer versus the controlling personnel. I think you can choose to read direct filer more broadly or narrowly, but it specifies that this individual has actually physically filed the document with the Secretary of State. Fairly direct and may include some relatively low on the totem pole people for your client if they're the one filing the business, or if you have your support staff doing it, it's something to keep in mind. You'll also know at the bottom here, this is a highlighted section of an email I received or my office received from one of the companies we use to file documents with Secretaries of State. And they note that Rossi in this case has a FinCEN ID number and it's on our invoice, so that if you decide that Rossi needs to be reported, you have Rossi's FinCEN ID number. And that FinCEN ID number, we're going to talk about again. It's a way to simplify your reporting system for repeat filers. And it's something that if you're an attorney having to do this a lot, I think you're probably going to want to do, because it simplifies your work and the work of your support staff in a helpful way. So what are you supposed to tell the government about yourself? You need some pretty basic information, and then two things that I think are a pretty big hassle. Names, date of births, address, fine. You also need to identify, to summarize this, you need to provide the details of a valid government-issued ID of one of these four categories. Provide the ID number, provide the state that issues it, and also a photo of it. This is the same for beneficial owners and company applicants. So it requires you to have a driver's license image or a passport image on your computer or on your system ready to upload. Your repeat filer solution is to get a FinCEN ID. This is very, very fast. I did it last week. Took about 3 minutes to do. You basically provide the information requested of you on this screen, and in return, they give you an ID number that you can share with clients if they're filing it on their own behalf, but you think you may need to be reported, or for your legal assistant to include on the filing. It's also helpful for people who are forming a lot of businesses. If you have clients who are regularly forming new LLCs, new subsidiaries, they're forming a new LLC for every investment property they buy, they may just want to get a FinCEN ID. Simplifies things, and it's free. On the logistics of reporting, the other point is that FinCEN has created a kind of API system where third-party companies are going to be able to automatically report in beneficial ownership information. So I think you're going to see a number of service providers not just offer data collection services to help you gather this information, but also reporting services, because it appears that FinCEN is going to work with third-party companies and for-profit companies to help simplify and automate this reporting process. The final thing that I know everyone will be wondering about is when exactly do you have to file these things? The law went into effect January 1st. When are you supposed to file? The middle bar on this chart talks that through. If you have an entity that was formed before January 1st, 2024, you have until the end of the year. I know a number of companies are choosing to wait and not file right now in the hopes that we're going to receive some more clarity about some of these more fuzzy questions about complicated ownership structures, for example. And so we may see helpful guidance later this year that may assist in that and provide some clarity. So I know a number of clients who are choosing to wait until closer to the end of the year. For entities formed this year, you don't have that option. You have 90 days to file and that 90-day trigger starts when the entity is formed with the Secretary of State, and you have the 90-day period from there. The deadlines are going to change to 30 days next year, but they provided a longer grace period. I would encourage anyone who's forming these businesses to just do it when you file the documents with the Secretary of State, or you may well forget. There's also an important piece to this. We talked about exemptions, companies that are exempt from having to report. If you fall out of an exemption, let's take, for example, the large operating company that requires 20 or more full-time employees and annual receipts of $5 million. If next year your annual receipts drop, you have to tell FinCEN that has changed within 30 days. In addition, on the flip side, if you have been filing as a company subject to this law, and you are now exempt, you've grown. Now you need to report within 30 days that change. The theory, I think, though I might be, giving FinCEN a little credit, is that you've been maintaining these reports and that they want to have kind of an end date of your last update.
Landon,
Yes.
a question regarding the example of the 20% owners.
Sure.
If each owner has a 20% interest and there is no one person who has substantial ownership, such as each owner is an officer with equal signing, equal voting privileges, does the corporation not file at all, or do they file anyway and detail how it all falls out in terms of management and structure?
An interesting question. I think the first part is, it's not uncommon for these entities to identify senior officers. That's an easier solution. That's my cop out a little bit when you have senior officers, or if this is an LLC, if you have all 5 of them are, managing members, I think that gets you kind of into the senior officer category. I think it's hard for a company to say that no one is a beneficial owner if a company needs to be reporting beneficial ownership information. So I think that could be a hard position to take. And I think what you'd want to refer to is there's that final, if you recall, and I may be able to scoot back to it moderately quickly. Let's see. Almost. There it is. If you look back at this important decision maker piece, I think that's likely where you're going to be spending time when you have kind of this 5 owners, equal control, no one's 20%. And so no one's meeting the ownership test. Let's say we have no one that's called a senior officer, but remember that if someone's acting as a senior officer, that is an economic realities issue. Under this important decision maker, people who have important decisions regarding the company's business and its finances, I think that's where you're probably going to be. There's an exemption for people who only have that decision-making authority because they're employees, but these 5 people are owners, 20% owners, not just employees of the company. So I think that's likely where you're going to want to work, and I suspect that a compliance-forward approach would be to identify all 5 of them. But
so a small family-owned business would fall under the important decision maker category rather than the ownership percentage category?
Ownership is 25%, and that is a fairly firm number. And so I think you're probably going to be more in the substantial control area.
And substantial control is differentiated from important decision maker? So
these 3 kind of buckets here are all ways that you can have substantial control. If you're the CEO of the company, you have substantial control. If you can hire and fire the CEO of the company, you have substantial control. And then if for whatever reason the titles aren't getting you there, but you have someone who decides important business decisions or has substantial influence over them, you have substantial control. So each of these 3 sub pieces are ways that you get to substantial control. Each one is sufficient. You don't need all 3.
What about board members?
Board members are hard. I've been thinking about that with a client of mine. It's not squarely addressed. I think that if you have someone who has enough power to unilaterally act within the board, obviously that gets you there. If you have kind of a 3 or 5 member board, none of which have kind of the individual power, it's something that I haven't hit yet in my practice, because typically, at least for my businesses, these board members are also senior officers. And so they kind of, they hit other items. I think if their only role in the company is as board member and as one voting member, and let's say they don't even own any stock, I think you may be able to fall out of the substantial control category, but I haven't thought about the boundaries as to how far you could take that or how aggressive I would want to be in taking that position.
What about a trustee in bankruptcy or a creditors committee? Would they be exempt?
That is a interesting question. And I believe there is some guidance in the FinCEN regulations on this type of situation. And so I think I would want to refer to that before filing anything. However, I mean, if unless there's an exemption, and I'm not sure if there is, I need to refer back to the regulations. It's potential. A trustee has a lot of control over this business. They're, functionally the only, the officer in charge. Depending on the facts, of course, not all trustees will have that power unilaterally. Those are kind of my off the cuff thoughts on that question.
So for everyone participating, I did put the link to the small entity compliance guide in the answered portion of the Q&A. So you can all find that link to go to the website that has these slides on it. But Landon, as we were talking before the program started, this is a brand new law.
Sorry, there we go. Thought this would help.
So, it's all because it's brand new, it hasn't been litigated at all. Right. And it is generally those subsequent interpretations that define the outlines of a law. So at the present time, there's no case law guidance. And so without that guidance, it's a tiny bit hard to give advice to a client. But I guess what you do, absent that subsequent interpretation by a bench somewhere, you just strictly follow the rule and hope you're doing it right, rather than try to find ways out of it. Would that be the right approach?
Yeah, I think there's, that don't want to throw up my hands and say business decision, because that's not a helpful answer. I think there's probably a compliance kind of priority approach, right? Which is, this person might not hit the elements, right? They don't have the ownership. They're not a formal officer of the company. They're on the board, but they're not an employee. They're just kind of on the board. They're not concerned about disclosing their role. We don't have an issue about we may not have a special privacy concern. And so I think, one option is to kind of defer to comply and report this information to FinCEN. Now, consequences of that, of course, is that this ownership information is accessible to FinCEN and to law enforcement agencies if they're ever investigating, the company or kind of conducting an inquiry. But, the consequences of misreporting, I haven't summarized it on the slide, though I've told clients about it when they get frustrated with this reporting. It's a crime to not report this information. There's fines that can be attached. And so, it's hard to know. I think, the bankruptcy example is a very interesting one, that I'm now curious about, but I'm not sure. I believe that one, working from memory, they may have addressed slightly in the FinCEN regulations. And so I definitely work through those when you have these type of more complicated clients. I also suspect that for a lot of clients, there's going to be simple clients with relatively straightforward filing guidelines that you might do as a flat fee or even just as part of your business formation. You set up the business, you file their FinCEN report, you tell them you're doing that, and it's just part of the package. And then there are going to be some clients with some really tricky situations. And if they want to give the federal government the minimum information required, then that's going to require some more work than someone who's willing to over-disclose slightly.
So back to our 5-person, 20% ownership. Mm-hmm. They don't qualify under the 25% rule because they each have 20%. Correct. Assume that they exercise no control over the business, that they have a president, chairman of the board, a CEO. They have all those officers that are separate from those 5.
Right.
I assume under the substantial control portion of the rule, the CEO, those types of officers would have to report.
Correct.
But you might not have to report the owners.
That's true. And I think let's take a truly passive investor, someone who has given money, you've done a friends and family round, for example, and you've gathered some money and they're truly passive. They own 5 or even 20% of the company, but they're not playing a big role. They're not deciding what the business does. They've given you some money. Hopefully they're going to get it back someday, but they're not managing the business necessarily. They might even be on the board periodically. Then you may be clear of that substantial control test, though I haven't thought through that all the way on a truly passive investor who's nonetheless on the board. But when you have if you have a more engaged investor, someone who's 20, 30%, no, let's say 20, 20% of the company, who maybe so. I think that's a challenge on where exactly the substantial control ends and how far down the line you go.
So it seems to me that given how steep the penalties can be, and if it is a crime for misreporting or not reporting, it seems to me that the initial risk is, until this rule has more interpretations, that you have to report. And if you have a truly passive investor, the company still reports, but you don't necessarily need to report that passive individual.
Yeah, and so there's kind of this two piece, right? The company, unless they're exempt, they need to report their beneficial owners, and they have to decide who those people are. And so, yes, I think, for a truly passive investor who's just investing funds and doesn't have enough ownership stake in the business to hit kind of that 25% threshold, they should be clear. But yes, to your point, there's, one option is if the business already exists from last year. I have a few clients who are waiting and want to file towards the end of the year in the hopes that they're going to see either some formal FinCEN regulations or people smarter than me kind of providing some think pieces on what this looks like on some of these gray areas. And so that's also an option. It's obviously not an option for everyone if you form the business this year, but that's a choice as well.
Okay.
And so I think the last piece that we can talk briefly, if anyone would like, is that there are some services that are provided that are around that I think can be helpful for people to use if you're trying to manage this thing. Thompson Reuters, Westlaw has probably been hitting up a number of attorneys and their law firms. They have a service, it's relatively expensive, that can provide, reporting on this sort of issue. A lot of registered agent services for your simpler businesses or people who are a little more do-it-yourself. A lot of registered agent services are offering Corporate Transparency Act reporting. And then I've also noticed on the complicated side, for those of you who may have clients who use equity managers like Carta, which is a service that kind of keeps tabs of who owns stock in a company, I believe they're also trying to roll out a Corporate Transparency Act tool. So for your clients that are sophisticated enough that they may want to keep tabs on this themselves, there are some kind of third-party services that I'm not sure what they'll be priced at, but that's something to watch. This is going to be an ongoing maintenance issue for companies. You have to report changes in 30 days, and that includes if the beneficial owner moves or their reporting information changes. They're supposed to tell the company that, and the company is supposed to report those changes. So the ongoing maintenance piece is going to be interesting to watch. But that's kind of my last piece on this.
I do think that much of the potential future litigation is going to center around what is a decision-making authority, those kinds of things. Mm-hmm. What about an influential minority member, like a dad in an LLC set up for an estate plan, or an oil and gas operator manager underneath a well drilling LLC? Mm-hmm.
Yeah, I think they kind of endorse. I don't know if the regulation uses the term economic realities. I know that shows up in the tax code a lot. But they do kind of have this kind of realities test that's frankly gray. I mean, it's a catch-all, and it's so that they don't get caught having forgotten to define somebody. But it causes some angst about who exactly we're supposed to be including in these reports.
I assume that because it's a brand new rule, well, I could be completely wrong. Hopefully there will be some flexibility as people work through the questions that this new rule presents. But the penalties require willful failure to report. What if you just make a mistake?
Right. I mean,
what if it's not willful?
Well, I mean, and I have not read through the penalties in detail. I think, when we're dealing with willfulness, innocent mistakes, you have some cover. I think more anecdotally, the language from FinCEN regarding, so they're rolling out some additional regulations about this rule, kind of continuing to update changes. At least their posture in their rulemaking is that they're trying to strike a balance between getting the information they think the law requires and overly burdening small businesses. And that could be posturing in their rulemaking for the benefit of the record, but it's something to keep in mind too. and who knows, it's frankly hard to know how firm enforcement of this is going to look like. The entity that's doing it is in charge of the Bank Secrecy Act, which has a lot of rather burdensome obligations on banks. I think this is a pretty big broadening of their mandate to some degree, right? They're moving out of some specific financial institutions and into largely any business in the United States.
So this leads me to sort of a two-part question. And we have one of our participants say that on the indirect ownership, you may want to look at the IRS corporate ownership, indirect ownership rules, because a definition might be included in there. And as a follow-up, what part does the IRS play in this? Do they have any investigative authority, or will it just be sort of, if FinCEN investigates, what could happen with the IRS participation?
Right. So I have first, as we've kind of talked about, and the member noted too, they borrow from the IRS code of law and treasury regulations in several places. And so I think in that role, the IRS is going to have a downstream effect because of how they interpret and modify treasury regulations. The second piece to that, which is not quite on point on this issue, but I wanted to raise, is that the information gathered by FinCEN, there is a rule for those who are most concerned about who can use this info. One of the reasons is for tax administration is the term used in the regulation. Exactly, I haven't parsed exactly what that scope looks like, but there is a rule on access to this database that I think for people who are concerned about privacy and what it might be used for should look at. As far as enforcement goes, the FinCEN is a subdivision of the Treasury Department, and so they're within kind of that Treasury framework. I haven't seen or looked too closely at kind of what enforcement is going to look like and who's going to be doing it. That's a fair question. I'm sure it's in there. It's not something I've chased down.
You spoke a little bit earlier about when an attorney names themselves as the incorporator.
Mm-hmm.
Where is the disclosure requirement on that person?
So the piece that you're looking for is the company applicant, is the language from the statute and the reg. And the company applicant is someone who is, and we can pull up the language if anyone wants to see it, but let's see here. These are individuals who who actually file or direct the filing of the entity formation documents with the Secretary of State. And so your clear example is if an attorney chooses to incorporate businesses for their clients, acts as the incorporator and files, and it's pretty clear. Our office has tended to be filing as a company applicant for the filer of these documents. Again, it's specified in there that, if you are the filer, you're the company applicant as well. This is not a backward going thing. It's only this year forward. But that is going to be based in the company applicant language. And the spot where you'll see that is kind of about who is a beneficial owner. Attached and addended to that is who a company applicant is. And the Small Business Compliance Guide also provides some commentary on that for anyone who wants the plain language version. FinCEN's kind of distilled it a little bit in that guide.
Well, we are out of time. I do think that most of the questions that are going to be faced are the indirect, direct, indirect ownership interest, the percentage ownership interest, the control, the business operational control. Even though this rule was promulgated to prevent, what did it say? Illicit activity, tax fraud, money laundering, financing terrorism. There is still so much gray area here that I would be surprised if there isn't pretty significant litigation moving forward because of these, what appear to me to be vagaries.
Yeah, and I think too, I'd hope that FinCEN is going to be flexible in what they expect of reporters and the initial kind of rollout of this thing. And hopefully we'll see clarifying regulations on some of these pieces. But And some of this, I think, is FinCEN just trying to keep their options open, on who they're going to consider a substantial controller. Because if you define a thing, people can try and circumvent that definition. So, there's this tension that I think is going to remain.
Well, Landon, thank you so much. I really appreciate you doing this for us. And like I told you before the program started, this is not my area of law at all. And I haven't practiced for a while, even in my area of law. So reading through this, I thought, oh my word, there's a lot of technical stuff, but also it appears to me to be some holes you could drive a truck through. So maybe as we proceed through this, what will happen is they'll be faced with a company that didn't report accurately and realize that they didn't define it and then roll out a reg. So it might just be pretty fact-based for the first little while, that they're like, oh, well, yeah, there's a gray area here. Let's clean it up a little bit. And maybe not.
Well, and I do think too that the IRS has used kind of the Q&A format. You saw it a lot with the employee retention credit, which is its own can of worms, where they provided incredibly detailed questions and answers and kind of FAQs. And so if they want to go short of rulemaking, we may see more of that type of guidance. But I'm not sure if FinCEN is interested in that approach. I know it's fairly common for tax. I'm not sure if it appears here.
Okay. Thank you, Landon, so much. I really appreciate this. So hopefully I will see you all soon at our next webinar, which is in 2 weeks. I don't have the calendar in front of me. And that will be on the intersection between immigration and family law. Landon, you're the greatest. Thank you, everyone, for participating. Hope to see you soon. Bye.